This is Paul Turner, the immigration barrister of Imperium Chambers. Apologies for the delay regarding this Balajigari update. I'm sorry for all of those who are becoming sick of the numerous Balajigari updates, but the matter of the outstanding judicial reviews and the Court of Appeal cases remains unclear as to how the UT and the Court of Appeal will dispose of the outstanding cases and what, if any, immediate remedies will be granted to the applicants concerned. In order to understand this a little more, one needs to go back to the stay order of the 14th of June 2009. Therein the Secretary of State provided a position statement of the 23rd of July, wherein the Secretary of State essentially conceded the outstanding judicial reviews. However, as mentioned in the previous recordings, there's a sting in the tail of the Home Office position. Firstly, notwithstanding that they accept Balajigari and therefore the Secretary of State's decisions are unlawful, the Secretary of State seeks to impose a number of potentially onerous conditions, circumstances on the individuals concerned. Firstly, the Secretary of State, notwithstanding paragraph 8 of the position statement, essentially conceding, then seeks to ask each individual to withdraw their JR. This would leave individuals without the right to work and without any lawful basis remaining in the United Kingdom for an indeterminate period of time. Also, why withdraw the cases if they have been won? It's a normal course of events for the Secretary of State to concede and pay costs. Withdrawal has the potential for individuals to lose the costs incurred in winning a judicial review and then being at the mercy of the Secretary of State's decision-making process, and it's painfully slow in my experience. As to the invitation for a right to work, I'm aware of around 30 such applications and they've all met with a resounding silence, save but two. This leads to the applicant's response. I'm aware that in at least two cases, so the applicants have been granted the right to work, and I've asked that they be treated that they are considered as if they were in effect in possession of Section 3C leave, also that they are allowed access, a letter that's issued to them that indicates that they will be given an opportunity to be treated as not having been found guilty of any deception, and that those that have returned home will be allowed to return back to the United Kingdom. Otherwise, winning the cases would be a Pyrrhic victory. The Secretary of State is due to respond, and the Secretary of State is due to come back and we're supposed to agree some directions. That has not happened as of yet. In my view, having effectively conceded, the Secretary of State ought to do what normally happens and put the person back into the position that they were prior to the decision and pay costs. This is what's happened in the cases in respect of TOEIC, in respect of the consent orders agreed at the Court of Appeal. But if the individual wins the appeal, they're put back in the position that they were before the decision. Given the fact that the Secretary of State is actually conceding these cases, the Secretary of State ought, in my view, to do the same. As I say, in my position statement, I've essentially asked for that to happen. If the Secretary of State cannot or will not grant Section 3C leave to each and every individual, the Secretary of State ought to issue at least the right to work, at least the right to rent, the right to drive, the right to access the NHS, essentially to put them in a sort of de facto, i.e. in reality position of having Section 3C leave until the Secretary of State gets around to actually addressing each individual case. And in particular, as I mentioned before, those that have returned home, which has happened in one of the cases, ought to have their return to the United Kingdom facilitated. Otherwise, what was the point of bringing the JR in the first place and incurring a huge expense? I'm currently liaising with the GLD and waiting for their response to the position statements that I've put in on behalf of two of the people in the stay cases. As yet, I have not had a response from the Secretary of State. I'm unaware as to whether the other two applicants in the stay order made any submissions at all. I believe in one case they didn't, but I'm not sure of that. What I will do is continue to liaise with the GLD, continue to push for the best possible outcome for all individuals affected, so that they are in essence back where they were before the decision was taken, given that it's accepted that the decision was unlawful, and so that they can carry on with their lives, work, earn, support their families, etc., until the Secretary of State gets round to remaking the decision. I say, at the moment things are in a state of flux and we don't know what's happening. As soon as I do know, I will let you know as soon as possible. Though my experience tells me that the Secretary of State is unlikely to agree to all the conditions, but who knows? It may lead to another further hearing, or it may lead to further negotiations. whatever happens, I will let you know as soon as I find out more. It's a short broadcast. I hope it updates individuals. I'm afraid I can't give you anything more concrete. I will do as soon as I can. Thank you for watching. This has been Paul Turner, the Immigration Barrister at Imperium Chambers.